Good afternoon. My name is Ken Manister, and this is the panel on the subject of security. I'm very glad to be here with our excellent group of panelists. From my left, we have Catherine Rotz, Deborah Perlstein, Eugene Fidel, and Daniel Farber. I'm going to dispense with the biographical information about each of our presenters, since you have that all in print in the program. It's fairly lengthy and very impressive, and I'm very honored to be here with these folks to assist in this discussion. I would add, I came here in what I suspect is, in two respects, rather unique ways. I'm pretty sure I'm the only person here who at 5:30 this morning was walking through the casino in Caesar's Palace, having just completed my very first trip to Las Vegas. So I've gone from the ridiculous to the sublime. But I think, given how little sleep I had last night, it's a real testament to the preceding panels that I have been awake the whole time. So that's good. The other somewhat unique aspect of my being here is realize there's a nice coincidence. This is the 40th anniversary of the dedication of the school in honor of Dr. King, and it's also 40 years since I've known and been very blessed to have a friendship with John Paul Stevens, one of my personal heroes, and happily for me, and he wrote it down once, so I know it's true, a friendship that we've had going back to 40 years, and a case that we worked on together when we were both practicing law in Chicago. Let me tell you a little bit, just our format will be as pretty much as it's been this morning. Each of our presenters will offer his or her thoughts on the paper for about 10 minutes, and then we'll proceed to, after all of the four presentations, we'll proceed to questions from you, and then discussion among the panelists, and I may pop in some questions myself. The topic is security, and as you will see, most of the papers to be discussed this afternoon concern security in the sense of national security. That is, concerns arising out of threats of terrorism, issues of protection of our national territory, and the conduct of military-type activities. Security, however, also has broader meanings, and these also will be addressed by some of today's presenters. And in thinking about the term security for today's panel, I was reminded of a wonderful book, won the Pulitzer Prize in History a few years ago, by Professor David Kennedy at Stanford. It's a history of the Depression and the World War II era. The book is called Freedom from Fear. And I recalled that Professor Kennedy said some important things about security, and I went back and let me just quote a little bit of what he says. He's speaking about the New Deal. He says, "The New Deal could be seen to have left in place a set of institutional arrangements that constituted a more coherent pattern than is dreamt of in many philosophies. That pattern can be summarized in a single word: security. Security for vulnerable individuals, to be sure, but security for capitalists and consumers, for workers and employers, for corporations and farms, and homeowners and bankers and builders as well. Job security, life cycle security, financial security, market security, however it might be defined, achieving security was the leitmotif of virtually everything the New Deal attempted," close quote. Professor Kennedy even goes on to speak of, quote, "a kind of security for the land itself," as he discusses the New Deal's addition of millions of acres of new national parks. And what I find particularly helpful about this perspective on security that Professor Kennedy offers is his juxtaposition of the word security with the word vulnerable. And I suggest that the two-sided coin of security and vulnerability is one we might keep in mind today as our speakers examine certain aspects of Justice Stevens's efforts to address the workings of the law, and especially the relationships between the courts and the other branches of government in this period of dramatic and challenging change and threat in our national experience. Among the concerns we'll be touching on are the vulnerability of our nation and its people to violent physical threats from human enemies, the vulnerability of our planet to environmental degradation, the vulnerability of many Americans to threats to their individual health and their economic well-being, and perhaps most critically, the vulnerability of our individual liberties and legal protections to infringement, even, ironically enough, in the name of national security. So I hope perhaps these comments are some help in orienting us to the presentations, and the first of our presenters will be Catherine Watts.
Thank you. As your introductory remarks obviously demonstrated, I'm here to talk about security, but I'm going to be talking about it in the broader, more expansive concept. Unlike my co-panelists.
I think you're getting signs that they need you to
use the microphone.
Move it closer. There you go.
Okay.
Unlike my co-panelists who will be focusing primarily on issues of military justice, terrorism, national security, I instead am going to, as a nod to Justice Stevens' famous Chevron decision and also his more recent blockbuster global warming decision in 2007 in Massachusetts versus EPA, I'm going to focus on his views on statutory interpretation in the administrative law realm. So why is it that I see a connection between his views on administrative law and security? I want to suggest that Justice Stevens' pronouncements on administrative law have a great deal to do with an evolving and expanding concept of security, embraced, for example, in recent United Nations literature dealing with the concept of human security. The expanded and evolving concept of security that has emerged recently moves beyond a singular focus on national and military security issues, but as Ken just noted in his opening remarks, also takes into account other safety and security-related issues, such as economic security, environmental security, and the public's general health, safety, and welfare, all areas that administrative agencies in the United States play an extremely pervasive role in regulating. In light of agencies' pervasive powers over matters that significantly impact the public's health, safety, and welfare, it's not surprising that much of administrative law focuses on what role the federal judiciary should play in policing administrative action and in ensuring that the public interest is properly secured. When it comes to policing agencies' interpretations of statutes that they execute and administer, perhaps there isn't any recent Supreme Court decision that provides a better example of the robust role that the judiciary can play in protecting and securing the public interest than Massachusetts versus EPA. In that case, Justice Stevens, writing for a 5-justice majority of the court, he handed a major win to global environmental security by ordering the EPA to reconsider its refusal to regulate certain emissions that lead to global warming. Specifically, he found that the Clean Air Act clearly and unambiguously authorized the EPA to regulate certain emissions, contrary to the EPA's own conclusion that it lacked the statutory authority to do so. What I want to do today is to try to put Justice Stevens' global warming opinion in Massachusetts into broader context. Specifically, I want to try to focus on whether Justice Stevens most accurately can be viewed as the advocate of a robust, non-deferential judiciary when it comes to securing the public interest in cases like Massachusetts, or instead whether he should be viewed as the proponent of a much more hands-off, deferential judiciary, as his now famous 1984 decision in Chevron could be read to suggest. In other words, I want to look at what Justice Stevens' approach is to securing the public interest in the regulatory arena when it comes to policing agencies' interpretations of statutes. Should he most properly be viewed as the proponent of a hands-off judiciary a la Massachusetts or a deferential judiciary a la Chevron? In trying to answer this question in the paper that will follow, I've analyzed various Justice Stevens opinions, concurring opinions, majority, dissenting opinions, that involve the reasonableness of statutory interpretations rendered by agencies. And when these opinions are viewed as a whole, I think a fairly clear picture emerges. One that perhaps isn't all that surprising, especially in light of comments that have come earlier today from, for example, Andy and Teresa, that have focused on how Justice Stevens is a very contextually driven jurist. a very holistic jurist in terms of how he approaches problems. So the picture that I've seen emerged in the cases I've looked at is that Justice Stevens can't accurately be viewed as really either the proponent of a robust judiciary or the advocate of a sort of counter-Marbury deferential type of a judicial role when it comes to defining and securing the public interest. But rather, he endeavors, in all cases, to act as a faithful agent of Congress. But in seeking to implement Congress's intent, one thing about his approach is particularly unique. Because he takes a very intentionalist approach to statutory interpretation, he's uniquely enabled to pay particularly close attention to Congress's own goals and purposes. This means that where Congress has enacted legislation with very broad protective or remedial purposes, such as the protection of our air, or the protection of our animal species, or protection of workers from discrimination, Justice Stevens pays particularly close attention to Congress's own broad protective goals and remedial goals. And in particular, he often gives protective congressional statutes a very broad rather than a narrow construction. So in the end, although he expressly eschews deciding cases based on his own policy preferences, his approach to statutory interpretation does enable him to facilitate Congress's own decisions about what will secure the public interest and protect the public interest. So in this sense, I want to suggest that Justice Stevens' approach to statutory interpretation in the administrative law realm is consistent with what some refer to as the remedial purpose canon, which provides that protective and remedial statutes should be construed liberally rather than narrowly to effectuate their beneficial goals and beneficial purposes. By giving a broad reading to Congress's beneficial goals and purposes, such as the desire to prevent against air pollution, Justice Stevens' approach to statutory interpretation uniquely helps to secure the public interest as it has been defined by Congress. So with the little amount of time that I have today, I'll give you just a couple examples of cases that I think help to illustrate this approach that Justice Stevens employs. Let me start with his dissent in Rapanos, a 2006 case that involved the question whether the Clean Water Act's protections extend to certain wetlands. In his dissent, Justice Stevens made clear that his conclusion, which ultimately supported the reasonableness of the Army Corps' determination that certain wetlands are encompassed within the Act, he made clear that this conclusion was in fact influenced by policy considerations. But he stressed that the pro-environmental policy considerations that influenced his thinking were Congress's rather than his own. And in particular, he called out the fact that he was seeking to effectuate Congress's own broad goals of trying to protect the physical, chemical, and biological integrity of our waters. Another example of this can be found in Babbitt versus Sweet Home Chapter of Communities for a Greater Oregon, a 1995 decision involving the Endangered Species Act. In upholding the Secretary of the Interior's regulation there that defined the ESA's prohibition of takings, Justice Stevens relied in part on what he called the broad purpose of the ESA. He ultimately concluded that the statute's broad purpose of preserving and protecting wildlife supported the Secretary's broad reading of the statute. A third example that I can point you to of his willingness to draw on Congress's own broad protective and remedial purposes can be found in his dissenting opinion in Sutton versus United Airlines, a 1999 case that involved the question whether myopic job applicants were disabled within the meaning of the Americans with Disabilities Act. In arguing that these job applicants should be entitled to the ADA's protections, Justice Stevens stressed in his dissent that the court's task should be to interpret the statute in light of the purposes Congress sought to serve. Congress's purposes and goals in the ADA were clear to Justice Stevens. The ADA was meant to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. In order to be faithful to this remedial purpose, Justice Stevens argued that the court should give the act, quote, a generous rather than a miserly construction. And specifically, he noted the remedial purpose canon, stating that it has long been a familiar canon of statutory construction that remedial legislation should be construed broadly to effectuate its purposes. So where do Massachusetts and Chevron, his two most famous decisions in this arena, where do they fit into this picture? In both cases, Justice Stevens endeavored to remain true to Congress's own goals and purposes. The end result being that in one case, Chevron, Stevens handed a loss to environmental interests, and he found that the EPA's interpretation of the Clean Air Act was reasonable in light of Congress's two animating policy concerns. Whereas in the other case, Massachusetts, he handed a major win to global environmental security, and he ruled against the EPA's narrow construction of the Clean Air Act. So Massachusetts and Chevron, when you view them together with opinions like Sutton and Rapanos and Sweet Home, I believe show us that he hasn't taken inconsistent approaches to the judiciary's role, but rather he strives in all cases, big and small, to act as a faithful agent of Congress and seeks to ensure that Congress's own goals for protecting the public's welfare and safety are furthered. So the picture of Justice Stevens that I hope emerges from my remarks today and will emerge in my paper is that of a justice who subscribes to an interpretational approach that enables him to construe statutes liberally rather than narrowly in order to effectuate Congress's own remedial and protective purposes. This means that his opinions, such as his global warming opinion in Massachusetts, often support results that could be seen as being highly protective of the public's general security, welfare, and safety. Yet in the end, it's Congress, not Justice Stevens, who has defined and set the protective and remedial goals in the first place. Consistent with the remedial purpose canon, Justice Stevens at most is giving a liberal rather than a narrow construction to Congress's own beneficial goals. Ultimately, I believe that this approach has much to commend it because it places the task of securing the environment, workplace safety, financial stability, human health, and other vital matters that impact the public interest primarily in the hands of those officials who are most politically accountable, yet it enables courts to ensure that Congress's beneficial protective goals are furthered.
Deborah Pearlstein is next.
Thanks. Thank you. First, thank you to Ken Manister and to Diane Amon. I'm just so honored to be included in this symposium honoring Justice Stevens, whom I so greatly admire, and to be part of this distinguished group of people who's included. I want to see, actually, before I launch into my talk, since this came up just before we came out to speak, a slight public service announcement. For those who follow the national security, post-9/11 national security cases at the Supreme Court, you might know that the last remaining U.S.-held enemy combatant, Ali Saleh al-Mari, his case had been granted by the Supreme Court while the Bush administration was still in office, with al-Mari challenging the legality of his detention under the authorization for the use of military force, which I'm going to talk about in my remarks, passed by Congress in the wake of 9/11. The Obama administration had come in and, I think just last week, filed papers asking the court to dismiss the case as moot, not clearly taking a position in its briefs that the executive had no intention of and would never again assert the power to detain anyone under the authorization for the use of military force as an enemy combatant, but nonetheless saying we have now indicted, or we are imminently going to indict al-Mari under federal criminal charges, have him transferred to civilian custody. He will be prosecuted criminally, and therefore there is no further need to decide the enemy combatant question. Moments ago, the Supreme Court issued an order granting the Obama administration's motion to vacate the case as moot. So the judgment's been vacated in the Fourth Circuit, which had ruled in favor of the Bush administration's power to detain al-Mari as an enemy combatant. And the case is remanded to the Fourth Circuit with instructions to dismiss the appeal as moot. We can talk about in Q&A if it comes up the significance of this ruling. I don't want to spend too much time on it at the moment, other than to say, perhaps by an effort to segue into the remarks I plan to make. The post-9/11 era, I think, it's easy to say, has produced more significant decisions on the constitutional authority of the executive and the role of the courts in time of national security crisis, just in terms of sheer volume, than I think arguably any other period in history. There were, of course, a series of cases out of World War II, and I think that's probably the closest in terms of number and rapidity of national security decisions coming out of the court. But this court, and Justice Stevens himself in some critical ways, has rewritten the case books on these critical questions about executive power and the role of the courts on matters of national security. And this case and this decision today is another example, even in the service of not deciding the particular question presented. Indeed, the question that I want to ask today is in some ways a bridge between Catherine's remarks and what I expect Jean's will be. And that is to ask, in the more traditional national security context, whether and to what extent Justice Stevens thinks that the court should defer to the views of the executive. In particular, defer to the views of the executive on questions of interpretation of national security statutes or laws passed by Congress that have some resonance in foreign affairs or national security. My paper, my talk had been tentatively entitled From Chevron to Hamdan, How Do You Square, or that was the title after the colon. I hadn't fully reasoned, but the question was, how do you square the fact that Justice Stevens, his greatest decision on this question of deference in the administrative law realm, Chevron, is most often announcing a remarkably deferential view to the views of the executive on questions of the interpretation of federal law. And his decision in Hamdan, this is the case challenging, ultimately a successful challenge to the military commissions created at Guantanamo Bay by President Bush to try enemy combatants held there, the military commission trials. In which I think the court exercised not Curtis Wright deference, not Chevron deference, but really no deference at all. How do you square these outcomes by the same justice? And the question is not mine alone. Since 9/11, there are a growing number of scholars who have responded to what were broadly viewed as enormously sweeping claims of executive authority by the Bush administration, with the argument that we should look toward Chevron as a means of cabining overly broad claims of executive deference. That is to say, instead of just granting the president essentially carte blanche to exercise his judgment on the meaning of federal statutes, we should at least engage in Chevron's famous two-prong inquiry. Recall, Chevron says that if Congress isn't clear what power it's delegating to the executive or authorizing the executive to exercise, then courts should defer to a reasonable interpretation of, in the administrative law context, an executive agency. So you have scholars sort of to the right, but really in moderate scholars to some extent. Kurt Bradley, Jack Goldsmith, Cass Sunstein, now with the Obama administration, Eric Posner, suggesting that this Chevron construct can helpfully inform the judicial interpretation of security statutes and treaties. And this comes up centrally in two of the cases, the post-9/11 cases that I want to talk about. Hamdi, which involved the interpretation of the authorization for the use of military force passed by Congress, and Hamdan, which involved, in part at least, the interpretation of the Uniform Code of Military Justice, the set of laws, statutes passed by Congress in its sort of modern form post-World War II, which generally governs the administration of military justice for the armed forces, but also has something to say about the use of military commissions. And the argument that Chevron is a sort of useful and meaningful test here is made by, among others, Kurt Bradley, who argues the Chevron doctrine is grounded in both functional and formal considerations. Functionally, it pushes interpretive lawmaking to government entities that have more expertise and democratic accountability than courts. And by allowing for changes in interpretation, it seeks to promote flexibility and regulatory governance. So the argument here is not that anything goes, whatever the executive agencies say, but that as long as the agency's or the executive's interpretation is reasonable, they have greater expertise than the court, and they have more claim to democratic accountability than the court in order to, and these two factors justify the court's deferring to an executive agency on a question of law interpretation. Well, one of the sort of key judicial thinkers who has not been on board with the let's apply Chevron to the national security context is Chevron's author. Indeed, in reviewing the executive's interpretation of the AUMF, the Authorization for the Use of Military Force, and the UCMJ, Justice Stevens was the opposite of deferential. So let me just recall briefly by way of background what happened in those cases before I talk about why it is he would essentially reject his own, why it might be he might reject his own efforts to expand the reach of his own opinion in Chevron. So recall in Hamdi, this was the case, an opinion came down in 2004, in which the question was whether the AUMF authorized the president to detain in military custody a U.S. citizen who, Yasser Hamdi, who was picked up in Afghanistan on the battlefield in 2001 after the U.S. invasion. And the authorization for the use of military force said this: the president is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. So all necessary and appropriate force against states, organizations, or people who may have been involved in the 9/11 attacks or in any way supported those organizations who were. So the scholar's argument would be, look, the president, in saying that all necessary and appropriate force includes military detention at a minimum, would say that's certainly a reasonable interpretation, as Chevron would say, of the authorization for the use of military force. After all, if the AUMF authorized the use of lethal force, as it surely did in Afghanistan, why not the lesser included force of engaging in detention of people picked up on the battlefield? But while the plurality ultimately agreed with the view that the AUMF authorized detention, neither the plurality of the court that prevailed in the Hamdi decision nor the executive relied on Chevron or anything like it. Nor did they rely on more traditional, broader claims of deference to the president on matters of national security. Instead, the opinion very much relied on the court's own take of the meaning of the law of war, the Geneva Conventions, and how that informed their reading of the AUMF. Justice Stevens signs on to the dissent written by Justice Scalia. So the two of them dissent together, saying the court doesn't go far enough in constraining the executive's authority here. That is, the only way, Justice Stevens and Justice Scalia argue, that the detention of a U.S. citizen could be authorized under a statute like this is if the statute intended to suspend the writ of habeas corpus. That is, the executive had said, we can not only detain these people, we have the authority to detain them with little or no process or review about whether or not their detention is factually justified or justified as a matter of law. Stevens and Scalia say no. There is the writ of habeas corpus. Unless Congress suspends it, they're entitled to the writ under whatever authority they're being detained. So not only do they not defer to the executive's interpretation, they say, look, not even the president says what the AUMF was doing was suspending the writ of habeas corpus. There simply is no way of deferring to the executive in the circumstances. So we're not even going to talk about it. In Hamdan, the question is somewhat more squarely presented. There, the Uniform Code of Military Justice, among the many sort of challenges presented to the court of the legality of the military commissions, was this. The Uniform Code of Military Justice, the UCMJ, authorizes, as a matter of statutory law, the president to set procedures for cases arising under this chapter, that's the UCMJ, tribal and military commissions. So the president is authorized by statute to set procedures for military commission trials. The question in the case was whether the Bush Military Commission violated the UCMJ rule, among others, that courts martial, the traditional mechanism for military trials on the one hand, and military commissions on the other hand, have procedures that are, insofar as practicable in the language of the statute, uniform. In other words, on the face of the statute, you could plausibly have different procedures for courts martial, which are very close to civilian criminal trials these days, and different procedures, lesser procedures in the protecting, lesser in the sense of fewer protections for criminal defendants in military commissions. But insofar as practicable, the statute said those procedures should be pretty much the same. The president argued in that case, look, in a very broad way, the courts aren't competent to second-guess the judgments of the political branches regarding the extent of force necessary to prosecute a war. Part of the force necessary to prosecute a war is the force necessary to try people for war crimes, the argument went. We say that includes no right to confront witnesses against you or evidence against you. Therefore, we win, says the executive. So it's a very broad, writ large argument about the connection between force on the one hand, trial secondarily, and then the procedural rules applicable in any trial the president creates under this authority. And Justice Stevens says, even though the statutory language seems to give the president rather broad flexibility to determine what procedures are practicable or whether or not it's necessary that these procedures be uniform insofar as practicable, Justice Stevens says, we may assume that such a determination would be entitled to a measure of deference, but nothing in the record in this case supports it. And indeed, even Justice Thomas in dissent in the Hamdan case says, doesn't look to any papers or anything in the record that the president filed in defense of the military commissions in that case, arguing for lesser burdens of evidentiary proof and so forth. Justice Thomas's dissent points to public statements that were made by various Defense Department officials, by various spokesmembers of the administration saying, well, there's a lot of classified information, we need to use different rules to protect that and so forth. There were various specific arguments available about why different procedures were necessary or practicable. The administration just didn't advance them in this case, and there was nothing in the record, a very sort of administrative law-like way of approaching the question, to support the idea that they were practicable. And therefore, the court concluded of its own authority, no deference involved, we see no reason why these procedures can't be the same. In other words, why military commissions can't proceed under essentially the same rules, procedural protections that UCMJ/regular criminal trials follow. And we're the court, the sort of final arbiter of interpretation, and we win. We conclude that it is practicable, that there's no practicability barrier. So what happened in Hamdan, and how can that be squared with Chevron, where, gee, if there's an agency or an executive authority with presumably greater expertise than the courts on questions of, say, military trials, and with a greater claim to accountability than the court, like the president who stands for election, why is it that Justice Stevens wouldn't just defer, or at least defer even a little bit, to the executive's assertion of authority there? And not only, and before I answer that question, I should just emphasize, not only was there not Chevron deference in this case, there wasn't Chevron plus deference, which one might have imagined sort of even at a higher level. That is the Curtis Wright view of the president as the sole organ of foreign affairs, which is, case books are written to say traditional executive authority in questions of national security affairs. The court is enormously deferential, far more deferential than what Chevron would require. And indeed, Justice Stevens even once cited the Curtis Wright opinion in one of his decisions back in 1993, the Haitian Centers Council case, holding that neither a statute nor an applicable treaty provided relief for Haitian refugees from being sent back, captured on the high seas by the United States, and being sent back to Haiti without asylum process, on the grounds that, look, executive authority in the area of foreign affairs, captures on the high seas and so forth, not necessarily requires greater deference to the president writ large, but Justice Stevens said at least gives the canon against extraterritorial application of statutes. That is, the statute that would apply if they were actually in the country. They would have to read it to apply extraterritorially. This at least gives us pause of ignoring the canon against extraterritorial application of statutes. So Justice Stevens was well aware that even broader degree of deference was available, and yet neither of these are sort of merited. I think there are maybe 3 reasons why, or I'm going to suggest there are 3 reasons why Justice Stevens doesn't do this. 2 have to do with sort of Chevron in particular and what Chevron may or may not mean. And the first is just a doctrinal argument. That is, since Chevron, there have been a series of cases, Mead and Christensen and so forth, suggesting that there's a Chevron step 0. That is an initial question, a threshold question about whether the authority Congress was delegating to the executive was authority to make rules with the force of law, or just to interpret and carry out the statute as the executive sees fit. And an opportunity for the court to conclude, well, yes, Congress was authorizing the president to use military force, for example, or to, well, let's use the AUMF example. But in carrying that out, in invading Afghanistan, it didn't mean for that action to carry the force of law. It just meant that to be an example of the conduct that was also authorized by the statute. So one might say, particularly in the case of Hamdi, if not Hamdan, where the language of the statute really does seem to authorize the president to create procedures for the carrying out of these military commissions. One could argue that, in most of these cases, whatever Congress was authorizing, it wasn't authorizing the president to actually go out and make laws about the meanings of these statutes. So that's one possibility. A second sort of statutory or doctrinal possibility was that Chevron deference never meant as much to Justice Stevens as it meant to the administrative law bar and to folks like Justice Scalia. That is to say, and there's sort of a famous debate that we can talk about, where ever since Chevron was handed down, there's been a battle between its author, Justice Stevens, and Justice Scalia. Justice Scalia claiming it rendered a huge change in the way in which courts relate to law interpretations of the executive branch and executive agencies. And Justice Stevens and others arguing, look, I didn't mean to do anything dramatic in Chevron at all. Really, I thought I was just writing, and if you talk to the clerk who worked on the Chevron opinion, I really just thought we were writing this opinion that sort of described what we thought the law was at the time. We didn't mean to change the face of administrative law for the following 30 years. And you can even see, in the years immediately following Chevron, language from Justice Stevens in related administrative law cases and immigration law cases in particular, trying to roll back the implications of Chevron and reassert or clarify his view that the judicial authority really is the final authority in the interpretation of law. So in a famous INS case, INS versus Cardozo-Fonseca, in 87, Stevens writes, "The judiciary is the final authority on issues of statutory construction and must reject administrative constructions which are contrary to clear congressional intent. If a court employing traditional tools of statutory construction ascertains that Congress had an intention on the precise question at issue, that intention is the law and must be given effect." So especially, he ends up concluding in different cases where the agency itself has taken inconsistent positions on the meaning of the statute, Chevron doesn't help you much. And indeed, many of the sort of post-Chevron cases, Justice Stevens ends up coming out on Chevron step 1. That is, the statute is clear, or in Justice Stevens' view, clear enough that we don't need to get to the secondary question of whether or not the agency's interpretation was reasonable. It's clear enough for standard judicial interpretive purposes. Here's what it means, end of analysis. So that's another possibility, that Chevron simply doesn't do as much work as some of its advocates and some of its proponents seeking deference to the executive would like to think it does. But I think maybe most significant in these cases, and I hope this will point us to in part the direction Jean is going. Well, look, if Chevron deference and Curtis Wright deference are just far too broad and take us too far afield from what the real judicial power is in Justice Stevens' view, well, at least executive views are entitled to Skidmore deference. This is a pre-Chevron administrative law case, which basically took a sort of totality of the circumstances approach to thinking about how much deference any executive interpretation was entitled to. Skidmore said, the executive's view, the agency's view, are at least entitled to deference insofar as they have the power to persuade. So surely, in the national security foreign affairs context, the executive's view should carry some rather significant, one might imagine, power to persuade. After all, the executive is the sort of the argument goes, federal authority and expert in matters of national security. And so surely he would win even just a Skidmore test of deference. But if you look at a case like Hamdan, which I think is just a particularly dramatic example, none of the factors the court looked to in Skidmore, and that Justice Stevens in his administrative law decisions has looked to consistently even after Chevron, ended up cutting in the executive's favor in Hamdan. And the factors, the Skidmore factors include things like how thorough was the process, how thoroughly was it evident that the agency considered the details, applied its expertise to coming up with an answer to the interpretive question, how valid was its reasoning, how consistent was this interpretation with its other pronouncements, and so forth. And if you look at, for example, the thoroughness of the process at issue in the creation of the military commissions, famously, and as became clear through the record of the case, and more importantly, some of the amicus briefs filed and declarations filed in the Hamdan case, the president, the executive, cut the military experts out of the process. That is, the JAG lawyers, the military lawyers who were expert in how one might conduct a military commission trial or how one might need to conduct a military commission trial, weren't part of the executive decision-making about how to design the military commissions. Similarly, as I mentioned, Clarence Thomas relied not on some sort of record of the executive or of the military saying, well, this classified information prevents us from following standard procedures. It just asserted the authority. And that mere assertion of authority without a clear indication of process, without a clear reliance on actual expertise, without a contextual, factual record, simply wasn't enough to persuade Justice Stevens that this view was entitled to any deference at any level, nor did it carry even much power to persuade. And I think for that reasons and others, his approach in Hamdan is not only consistent with Chevron, but consistent with the theme we've been talking about through much of the day. That is, the belief in, reliance on expertise, or at least the possibility of some contextual answer to the question being relevant, I think was very much at work in the Justice's decision-making in Hamdan and his decision not to defer to the executive on the question of what we need to do in military trials in the context of counterterrorism. So I think I'll stop there and turn to Dean.
This symposium reminds me of a party I once went to where essentially everybody had been a law clerk for somebody. With a lot of praise for the judges and justices for whom they worked. All of it merited, I'm sure. But it left me feeling a little bit out of it. So with one of the other non-former law clerks who were present at the party, I created a judge named Luther A. Wilgarten, Jr. And we invented this whole persona for him that he'd been on the Western District and moved up to the Court of Appeals at some point. Don't ask which Court of Appeals. Don't ask which Western District. And slowly have over the years been painting in his history, such as his affection for saltwater taffy, his collection of historic warehouse receipts, and his treatise, Wilgarten on Bulk Sales. So now in its 5th edition. We even had a couple of clerks' dinners, by the way. What we need is a Wilgarten symposium. So let me ask the law review, if you're here and listening, this is what comes next. I have a feeling that I'm kind of a party crasher since I'm surrounded by clerks of Justice Stevens, but if I can be forgiven, I'd like to offer a few comments. With the death of Chief Justice Rehnquist, Justice Stevens became the only sitting justice to have served in the military in wartime. Yes, I know Justice Kennedy served in the California National Guard for a few months after he graduated from law school in 1961, but let's set that aside. The chief had served as a sergeant in the Army Air Force from 43 to 46, turning down the opportunity for a commission. while Stevens had served as a naval officer at Pearl Harbor from 42 to 45, analyzing, as Diane mentioned, intercepted message traffic and decrypting enemy call signs, and eventually attaining the grade of lieutenant commander. Whether or not their differing stances in cases relating to the armed forces reflect their personal experience in uniform or as law clerks, Justice Stevens' careful and, I think, non-doctrinaire approach in such cases is of a piece with the Supreme Court's World War II approach in Duncan against Kahanamoku, where the majority rejected military claims that it was necessary to employ military courts in Hawaii after Pearl Harbor, and a far cry from the uncritical deference that typified Chief Justice Rehnquist's decision-making in cases such as Goldman against Weinberger. Those who have served in uniform can attest that military service is a vivid experience, even if one did not see action in combat, and even if one's period of service was not as long as his. Speaking with lawyers who served in World War II and the 1950s, I've regularly been struck by their ability to recall the details of cases a lifetime ago. People also form personal habits and an outlook in uniform that may stay with them forever. I've never interviewed Justice Stevens. I can't say that his naval service played such a role, but it's interesting to speculate that the approach apparent in his votes and writing in military-related cases in some sense may reflect his years in Hawaii. Let me discuss two cases, Goldman against Weinberger and Hamdan, which has already been mentioned. Goldman was concerned an Air Force psychologist who wore a skull cap while in uniform. This is contrary to regulations, but it became a serious issue only after he testified as a defense witness in a court-martial. I found the case disturbing, both because it seemed to me about as clearly wrongly decided as any I can think of, but also because it seemed unwise to cast the issue as Captain Goldman's counsel had done. I thought from the beginning that it would have been much more productive to frame the case as one of retaliation forbidden by the UCMJ. In any event, the court, in a brief opinion by then-Justice Rehnquist, rejected Goldman's free exercise claim, holding that the challenge portions of the uniform reg reasonably and even-handedly regulate dress in the interest of the military's perceived need for uniformity. No pun intended. The First Amendment, Rehnquist wrote, does not prohibit them from being applied to petitioner, even though their effect is to restrict the wearing of the headgear required by his religious beliefs. Not surprisingly, given his own admission that he had in the service, quote, learned to obey orders, Rehnquist invoked the case of Chappell against Wallace, where the court had observed that the inescapable demands of military discipline and obedience to orders cannot be taught on battlefields. The habit of immediate compliance with military procedures and orders must be virtually reflex, with no time for debate or reflection. The desirability of dress regulations in the military, he added, is decided by the appropriate military officials, and they're under no constitutional mandate to abandon their considered professional judgment. Stevens found himself allied with Justice Rehnquist in the majority. He joined Rehnquist's opinion of the court, but he also wrote separately. Joined by White and Powell, each of whom had served during World War II, Stevens began by acknowledging that Captain Goldman presents an especially attractive case for an exception from the uniform regulations that are applicable to all other Air Force personnel. The opinion goes on to recognize in a variety of ways both his personal devotion and the authenticity of the yarmulke as an expression of deep, long-standing religious belief. All this, however, is trumped by the, quote, interest in uniformity, which he notes has a dimension that is of still greater importance for me. It's enough for him that, quote, professionals in the military service attach great importance to the plausible interest in uniformity as such, quote, even though personal experience or admiration for the performance of the ragtag band of soldiers that won us our freedom in the Revolutionary War might persuade us that the government has exaggerated the importance of that interest. What led Justice Stevens to write separately? His concurrence never tells us directly, although it seems that he thought the regulation had to be tested not only as applied to Captain Goldman, but also as applied to all service personnel. He was concerned that the decision not afford a basis for differentiating among faith groups, a point nowhere made in the opinion of the court, so that a soldier who was an observant Jew might fall on one side of the constitutional line, whereas the religiously driven appearance of a Sikh or a Rastafarian might fall on the other. Justice Rehnquist's opinion of the court did not address this dimension. In other words, Justice Stevens saw the interest in uniformity in two dimensions, within the armed forces as a whole, but also across faith group lines. Reading between the lines, it's tempting to believe that this was a conclusion with which Justice Stevens was not entirely at ease. His observation that, quote, personal experience, as well as respect for the ill-clad heroes of the Revolutionary War, might lead one to question the importance attached to military claims that perfect uniformity in dress is critical, sounds autobiographical to me. Additionally, his emphasis on Captain Goldman's personal sincerity and a footnote reference to the role of anti-Semitism in American history sound like protesting too much. But however he actually felt about the outcome, his concurrence underscores the extent to which he is, or was, ultimately willing to defer to the judgment of military professionals, even when there's something of considerable moment on the other side of the scale. Happily, from my perspective, Congress responded promptly to Goldman, enacting a statute that acknowledged the need to accommodate religiously driven exceptions to military uniform regulations. That law called for the issuance of regulations, and the area has, on the whole, been free of controversy since then, although issues have arisen about wear of a hijab by Muslim women. Now to turn to the Hamdan case for a minute or two. This case deserves close study for, among other things, what it reveals about the virtues and weaknesses of minimalism. And others have already spoken. Deborah has mentioned it during the symposium. The case, one point in the case that I think deserves greater attention, and I'm glad that Deborah mentioned it, is the debate concerning Article 36 of the UCMJ, which is the rulemaking provision, or the grant of rulemaking power to the President. Article 36 has two parts, both of which Congress amended after the Hamdan case when it passed the Military Commissions Act of 2006. Article 36A concerns what I'll call conformity. It sets district court practice as the benchmark for court-martial practice in the absence of a countervailing statute or an impracticability determination by the President. Article 36B concerns uniformity. Both concepts came into play in Hamdan. Justice Stevens concluded that in order to satisfy Article 36A and meet the regularly constituted court requirement of Common Article 3 of the Geneva Conventions, military commission procedures had to conform with court-martial procedures. Justice Thomas, in this instance, had the better of the argument with respect to Article 36. To understand why, a short history lesson is required. The Articles of War preceded the UCMJ. They were the Army and Air Force disciplinary statutes. As enacted in 1916, Article of War 38 included a rulemaking provision very much like what is now Article 36 of the UCMJ. It included no uniformity clause, even though it applied to both courts-martial and military commissions. That uniformity clause, which played a pivotal role in the Hamdan decision, appeared in 1950 when Congress enacted the UCMJ, creating for the first time a single military criminal code applicable to all branches of the armed forces. Quite simply, as Justice Thomas explained, the uniformity clause was intended to ensure uniformity from service to service rather than from courts-martial to military commissions. On the other hand, Justice Stevens' willingness, along with Justice Kennedy in Hamdan, to probe executive branch assertions that it was impracticable to follow court-martial procedures in the pre-MCA military commissions is correct. And there's no doubt that the empty assertions in President Bush's November 13, 2001 military order that set the stage for the pre-MCA military commissions, even with the additional comments of subordinates that Deborah mentioned, were deficient. That, by the way, may be the simplest explanation for the mystery of an apparently divergent approach between Chevron and Hamdan. It may be a very simple matter. The military order itself offered no specifics in support of its determination that district court prosecutions were impracticable. District court procedures were impracticable, all President Bush said in the military order was that there was a danger to the safety of the United States, and there was something about the nature of international terrorism. That's all that the executive branch provided by way of a contemporaneous explanation of why it was impossible to use or follow district court procedures. This was a transparently deficient rationale, and it asks the impossible of a coordinate branch, even a coordinate branch as friendly, let's say, as Chevron is to executive branch discretion, know-how, whatever. I think the judiciary would have been entirely willing to defer if it had been given a rationale by the White House that contained even a modicum of substance. Let me add, by the way, that if an impracticability determination is flawed, what's the result of that? There's an article by Professor Estreicher and Judge O'Scanlan suggesting that a Chenery-style remand is appropriate. Here you see the convergence of national security law and good old-fashioned administrative law. A remand was appropriate to afford the president basically a second bite at the apple. The court took the position that recourse to court-martial norms, however, was required, as indeed is suggested by the preamble to the Manual for Courts-Martial. Now, this may be sound as a matter of international law, but what if Article 36A dictates otherwise? I happen to agree with the outcome in the Hamdan case, but the statutory default mode, and you have to go back and read the statute. The statutory default mode for military commissions at the time is district court practice rather than court-martial practice. Accordingly, if the president's determination that conformity with district court practice was impracticable was deficient, shouldn't the result have been a ruling that required conformity with district court practice rather than court-martial practice? It's unfortunate that despite their dueling references to Article 36, the justices seem not to have had this aspect of the statute in proper focus. Now, my purpose in these remarks is not to offer a pop psychology take on Justice Stevens. He's too subtle for that. I think everybody who's listened to the comments today would have to agree. And I don't know him, and I don't feel competent to opine as a result. However, I think it's fair to take note of the persistence and the importance of military matters in the court's recent jurisprudence and to consider whether, pop psychology aside, there are some institutional implications in the pattern. The country is curious and in many cases anxious about what the court's direction may be when, inevitably, vacancies arise and have to be filled. Must the next appointment go to a woman? A Hispanic? Are there too many Catholics? Too many Jews? Too many Harvard and Yale graduates? Too many former Supreme Court law clerks, sorry. Is prior service as a federal appellate judge essential, merely desirable, as Chief Justice Roberts recently suggested, or is it undesirable? I'd like to offer a further dimension for that conversation. Do we need more justices who have served in the military? No, I'm not running, and I won't say I will not serve if I'm named, but my hat is not in the ring. This is an idea that I hope the judge pickers in the administration, as well as the Senate Judiciary Committee, will at least entertain. My reason for raising it is not only in the interest of broadening and enriching the experience base of the justices, which is in principle a good thing, but more particularly out of concern that justices and federal judges generally who have not served in uniform may be or may feel, which I think amounts to much the same thing, at a disadvantage when dealing with this specialized field, even though they seem utterly lacking in fear when it comes to tackling equally or more arcane or inaccessible areas of the law. Take your pick. Phrases like deference being at its apogee or separate and distinct society come to mind repeatedly when you read the court's cases in this area. I believe that judicial caution can confer on the government so significant and at times so undeserved an advantage as to erode the adversary process in our highest court. To be sure, whether and how any particular veteran who is elevated to the bench is influenced by military experience will vary, But counterintuitive though it may seem, my personal sense after many years of practice and observation is that judges with some military experience are less likely to defer, at least around the edges, than those with none. Plainly, it would be as improper for justices with military experience to assume the mantle of a specialized court as it would be for a trial judge to rely on personal knowledge of surgery when deciding a medical malpractice case. But it does seem fair to suggest that having one or more veterans in the conference could add to the robustness of the discussion and hold out the promise of careful scrutiny of government claims that might otherwise be embraced uncritically. Experience since 9/11 teaches that the justices are not reluctant to test and, when appropriate, reject government claims sounding in military or national security. But the executive branch's litigative experience in these fields is so profound and so hard to match, despite the impressive mobilization of the civilian bar in the wake of the Guantanamo and other enemy combatant detentions, such as the one that Deborah just mentioned a few minutes ago, that a cautious approach seems justified. It is not desirable in a democratic society that the government have what amounts to a monopoly on learning or credibility in these areas, and it's therefore a good thing that law schools are increasingly offering courses in military and national security law. It's likely that there are only a handful of lawyers with the usual credentials to be plausible candidates for appointment plus military experience. An appointment strategy that took particular note of military service may therefore be difficult to achieve when the next one or two vacancies arise. But as time goes by and increasing numbers of talented young people with military experience gained in the first or second Gulf Wars or in Afghanistan or, God forbid, someplace else find their way to the law schools and enter our profession, I am certain that those responsible will have no difficulty finding highly qualified veterans to serve on the court. I'm confident among them, or perhaps the generation that follows ours, will find another Holmes, another Brennan, another Powell, another Rehnquist, and another Stevens. Thank you.
I personally favor the appointment of law professors who have been Supreme Court clerks, but that's a topic for another time. I'm under very strict instructions to stick to the timetable so that we can get done in time to leave room for plenty of audience participation. In addition, since my topic is federal jurisdiction and this is Friday afternoon, I'm reluctant to impose too much on your patience.
Thanks, Dan. That was great. We really appreciate it.
Well, you got me out before I could get into trouble. So I'm also going to be talking about the Hamdan case, which I think clearly is figuring as a major part of Justice Stevens' contribution to the court's jurisprudence, as well as his opinion, especially other opinions in the War on Terror cases, particularly Rasool. These cases involve what may seem like a very esoteric question, and when you read the arguments in the cases, they're even more esoteric. The question is the applicability of the habeas jurisdiction under various permutations involving Guantanamo. Now, as I say, this is a question of federal jurisdiction. It's not one that necessarily stirs the heart or dominates the headlines, but it's critically important because without habeas jurisdiction, essentially the federal government or a state government would be free to detain anybody, anytime, for any reason or for no reason. And in that sense, habeas is the most fundamental guarantee of rights and of the rule of law that we have. Historically, I think some of the other speakers have mentioned, in crisis times, the Supreme Court has tended to defer very strongly to the executive branch. That's true not just in World War II, but in World War I, during the Civil War, during the alien and sedition dispute in the early Republic. Courts typically have more or less run for cover during a crisis period where national security is at stake, or at least seems to be at stake. And there was every reason to expect that this would also prove true during the recent years since 9/11. I suspect that when we have the full benefit of the archives and of the recollections of the people who were involved, that we will discover that Justice Stevens played an even more important role at the Supreme Court than is indicated by the published opinions. But the published opinions themselves are very important because of the fact that they establish that the federal courts have the authority to be involved in this area. And without those jurisdictional rulings, the court would never have gotten to the question of whether the military commissions were properly constituted, or indeed whether there are any limits at all on the government's right to detain or punish people outside of the United States, including Guantanamo. So the really critically important issue. There is a kind of preview of Justice Stevens' habeas Guantanamo decisions in an earlier habeas case just before 9/11 called St. Cyr. And St. Cyr is a case that I would be surprised if at most one or two people in the room have ever heard of before, and if they have, it's probably because they study immigration law or are really immersed in federal jurisdiction. The question in St. Cyr was whether the court could review a decision by the Attorney General to suspend deportation in light of a federal statute that purported to eliminate all, quote, judicial review of the Attorney General's decisions except through a specified mechanism that didn't apply. In an opinion by Justice Stevens, the court held that the term judicial review in this setting did not include habeas as a matter of the technical usage of immigration law, that the court did have jurisdiction, and the court went on to reverse the Attorney General's view of the law. One thing that made the case especially notable is that Justice Stevens articulated a clear presumption in favor of habeas jurisdiction, given its historical importance, and but didn't rest only on that ground, but on very close reading of the legislation, the law in the area, and the legislative history. There's a very strong dissent from Justice Scalia, and so we see set up before 9/11 some of the disputes that are going to come back in the more vital context of the detainee cases. Justice Stevens wrote three major cases dealing with Guantanamo. One, a dissent in the Padillo case, and for reasons of time, I'm not going to talk about that. And then the Rasul and Hamdan decisions. Rasul was the case that said that habeas jurisdiction extended to Guantanamo. And the Bush administration had chosen Guantanamo in part because of World War II era decisions that seemed to say, or at least could easily be read to say, that there is no habeas jurisdiction outside of the territorial limits of the United States except for U.S. citizens, and that therefore any alien held by the government outside of the United States had no right to habeas and therefore no rights at all. Justice Stevens distinguished that case, reading it rather narrowly, and then viewing it as being fatally undermined by another decision interpreting the habeas statute in a very different context. So he disposed of that opinion in a very lawyerly way, and then he turned to the question of whether Guantanamo was a place where habeas jurisdiction would run. And that's an interesting question, and one that I think makes a really nice test of how deeply formalist you are. Because the agreement between Cuba and the United States essentially gives the United States absolute authority over Guantanamo until such time as the base is no longer used for naval purposes, which appears to be never, as far as I can tell, and at the same time provides that, quote, ultimate sovereignty still resides in Cuba. So Cuba has the formal title of sovereignty, as to Guantanamo, but none of the rights of the sovereign. As the retired judge who argued the case said, a stamp with Fidel's picture on it won't get your letter off the base. Right? There is nothing about this base that is subject to Cuban law. Justice Stevens, elevating substance over form, said that clearly this was, for all intents and purposes, U.S. territory and that habeas does run there. Justice Scalia, elevating form over substance, reached the contrary conclusion. Justice Stevens did not write in the most recent case, Boumediene, which involves whether constitutionally habeas runs to Guantanamo, but as a concurring opinion that he tactfully did not join points out, essentially the majority opinion tracks his Rasool reasoning. So that I think his not writing is probably more of a desire to back up the writer of the opinion, Justice Kennedy, and to avoid tooting his own horn. But clearly the case is very deeply shaped by his Rasool opinion. Now, Hamdan is a very interesting case on habeas. What happened was that the Supreme Court agreed to hear the case to decide the legality of the military commissions, and then Congress passed a law depriving all courts of habeas jurisdiction over Guantanamo. And instead, Congress provided a post-conviction appeals route that was limited in a number of ways, and which the court would later find to be not a constitutionally acceptable substitute for habeas later. The court could have reached that ruling, and Hamdan could have reached out and decided that constitutional issue, but instead Justice Stevens wrote an opinion holding that the new statute didn't apply to pending cases, and that therefore the court retained habeas jurisdiction, despite a statute which says no court has jurisdiction in habeas. Again, it's a very lawyerly decision. He relies largely on two points. Number one, the Supreme Court's general presumption against retroactive legislation, which he applied here. And number two, a very interesting nuance in the language. The statute has together three subsections. One of them involves this, and the other two, right next to it, say that those subsections shall apply to pending cases. And so Justice Stevens says, well, they said it in the other two, they didn't say it here. They must not have meant this one to apply to pending cases. There's a very lawyerly decision. Justice Scalia replies with his usual nuance and subtlety, accusing Justice Stevens of ignoring not only well-settled but previously unquestioned law to the effect that restrictions on jurisdiction always apply retroactively, without exception unless Congress explicitly says to the contrary. I actually spent quite a bit of time looking at the cases Justice Scalia relies on because I was interested in whether Justice Stevens was correct when he said that he was relying only on normal, everyday principles of statutory interpretation rather than any special solicitude for habeas. If Scalia is right about this ironclad existing rule, then Stevens is clearly doing something that's out of the ordinary. After looking at all of the cases Justice Scalia cites, actually when I started to look at them, the first thing I noticed was that except for one, they were all before 1900. So that was one immediate question. In any event, let me say that I think that Justice Scalia's position in the case is not without some basis, but that if you look at the cases and you look at the more recent cases cited by Justice Stevens, I think Justice Stevens pretty clearly has the better of that very technical argument. Now, as I said, these are very lawyerly cases. There's not much there to make into a soundbite or to headline on the front page of the newspaper. Unlike Justice Scalia, Justice Stevens usually writes for his fellow judges and lawyers rather than for the gallery. But despite the understated and technical nature of these opinions, I think they stand for something very important that runs through much of Justice Stevens' jurisprudence, and that's a deep belief in the rule of law, in the importance of adherence to law, adherence to the legal process as an important guarantee of civilization. Many people, I think, view the legal process as more of a nuisance or another form of red tape than anything else. I think that's clearly not Justice Stevens' view. He views the process as being worthy of respect. He stands, I think, for an unapologetic view of law and lawyers, even, as central to the maintaining a free society. You see that not only in these big cases, but for example, there's a case that many years ago involving a limitation on fees to lawyers representing veterans in disputes with the government over their benefits. The fees were restricted to $50. Justice Stevens viewed this effort to cut lawyers out of the process, which is what it was, as really being a frontal assault on a basic social value. So that's a rather arcane example of what I think is a passionate attachment to the importance of the legal process. I think one of the things that Justice Stevens is going to be remembered for is standing up for the rule of law at a critical juncture in history, and all of us who have been associated, even in small ways, I think have a special reason to be proud that he played that role. Thank you.
The sentiment of the panel was that we would begin by inviting questions from the audience. And yes, sir.
Just 1 second. Stand up. Well, anyway, in all these statutes you've mentioned and the cases you've mentioned, which I must tell you I haven't read them, so I might sound a little dumb here, but I would like to ask. Did Justice Stevens or any of the other justices, for that matter, you know, in the view of the fact that all this is, everything that's happened during this period has been in a climate of an imagined national emergency, an imagined terror attack on 2001. So I was wondering if Justice Stevens, or any of the other justices for that matter, in any of their opinions, ever expressed any doubt or question as to whether there ever was a terrorist attack in September of 2001.
I always wanted to give a one-word answer to a question, and I never, as a professor, never seem to be able to, but I can do it this time. No. They haven't.
Other questions? Yes.
I don't mean this in the nature of a pop quiz, but if anybody's read the 2 really interesting opinions that came down just this week by Justice Stevens, both have to do with deference and Chevron. One was his major opinion 2 days ago in the FDA preemption case, really interesting, where he says the government's position is entitled to no deference, basically because it wasn't properly arrived at. And then a separate concurrence in an immigration case, Negussi, where he gives his current view of what he meant by Chevron, which is exactly as Deborah said, which is to say not as much as everybody seems to think. So I just wanted to give you a chance to comment on those, because those are 2 really interesting opinions.
Yeah, it has been a big week on the deference front for Justice Stevens, and I think those 2 cases speak perfectly into Deborah's sort of 3 thoughts as to what might be going on. Negussi feeds perfectly into your thought that maybe Chevron isn't what everybody's saying it should be. It's basically Cardozo-Fonseca all over again, just years later, in terms of him reiterating his view that Chevron didn't do all that much, and also reiterating his view that when we're talking about a pure question of statutory interpretation, that's not what deference is all about. So I don't know how that might feed into your thoughts there. And then the other thing in terms of Wyeth, the preemption case that I was wondering about with respect to Deborah's discussion is in the preemption context, Justice Stevens has been so clear that he's really anti-deference, especially anti-Chevron in the preemption context, in part because of these constitutional undertones or overtones, however you want to think about it, federalism issues in terms of the state's representation. And I wonder if there might not be some analogy there in this context as well. I realize it's not constitutional issues per se, but nonetheless the kind of overtones and undertones in these sorts of cases, these terrorism sorts of cases, if that might have some kind of a connection to his Wyeth type of views, his preemption views, where he is opposed to giving a lot of deference when it comes to preemption matters.
Well, I'm always delighted to have more fodder for my argument brought into it. So no, that's great. I actually think, as I was reading through, kind of the ad law cases from Chevron to Hamdan, Stevens, it really seemed to come very much to the fore, and I think this is just the total logical conclusion, if not conclusion. I mean, he really has spent the last, 25 years fighting back against the notion that Chevron in any way diminishes the judicial power to interpret the law, and pushing back hard, if in not quite a Brierly way, in a Stevens-esque way, on the idea that when we say, expertise is worthy of deference, we don't mean authority is worthy of deference. We mean actual facts and knowledge and context and so forth. And in the national security context, if I had to sort of soundbite it, would be the president is not an agency. In the ad law setting, you actually do have agency processes, and process can mean something. In the national security context, often the decision making, and certainly in this past administration, the decision making was happening in a black box. So unless there was some very active affirmative showing that a vigorous process could overcome the lesser showing of, we didn't really say anything specific about the details of or the expertise of why we think this is the case, then he's not buying it. And I guess I think the one other thing I just wanted to say, kind of picking up on both of these points, is a little bit more of this historical context, right? So Stevens was the Rutledge clerk. And Rutledge, famously deferred along with the majorities in sort of Hirabayashi, Korematsu, to FDR, the commander-in-chief, and, military commanders on the ground who said these programs, these detention programs, et cetera, exclusion programs, were a matter of military necessity. And my sense from reading the history, and Craig Green has a wonderful article on this, is Rutledge spent much of the remainder of his tenure on the bench, beginning 3 years later in Yamashita, coming to grips with his regrets over the amount of deference and the lack of questions he asked of the military as agency in those questions about what is it exactly that leads you to conclude this is a necessity. And to me in these decisions, Hamdan certainly, in the national security context, very much, without pop psychologizing, I think one can trace the historical line pretty clearly to, Rutledge's lessons didn't ask enough questions, and Justice Stevens' manifestation of that lesson is, you better have a really good, here's the questions, they're the Skidmore questions, and you better have a very good and very clear answer. The military is no different from anything else in that capacity.
I just toss a couple thoughts in response to this. What was striking during Catherine and Deborah's presentations, it seems to me we talk so much about Chevron deference, but looking at these cases, we're really talking so much more about step one than we are about step two. And it reminds me of sort of some of the things Andrew was saying about how do we deal with the fundamental starting point interpretive question. How do we resolve the issue of interpreting the law, deciding whether it's clear enough? So we're never going to really get to the deference issue. And perhaps others, maybe I'm off base on this, but it seems to me that's really so much of what we're talking about. And frankly, when you refer to Skidmore, that confuses me a little bit, because that suggests, well, maybe we have gotten to a step two, and then the question is what's the level of deference. But I'm not sure in these cases we're even really getting there. The other thought I had is part of what I find so troubling about this area of law is it seems to me the dilemma that we seem to be coming up against repeatedly in these national security related cases is there seems to be the strongest arguments for deference to the expertise and the political judgment, and even in administrative law terms, the highly discretionary judgment of the chief executive with respect to foreign affairs and issues of war making. And at the same time, it seems to me we have the greatest need for independent judicial assessment of what's being done, and that both those things are going on at the same time. I don't know if anyone wants to comment on that, but it strikes me that dilemma is really part of what we're struggling with.
Yeah, let me pick up on the second part of that. I mean, it seems to me that one of the reasons why Chevron doesn't necessarily seem like a good fit here is that Chevron, to the extent it adds anything to the previous idea that you defer to the executive when the executive has greater expertise, the additional language that got everyone excited in Chevron was about the sort of more majoritarian nature of the executive and how that political accountability was a basis for deference. And that's fine, except when we're expecting the court to play a counter-majoritarian, or at least non-majoritarian role in protecting individual rights. And at that point, the fact that the executive branch is more majoritarian is at best irrelevant and perhaps, in fact, a negative. That is that to the extent that we think that the president is more responsive to public opinion, and to the extent that we think the public may not be very sensitive to the need to protect individual rights during a crisis, that actually somewhat undercuts the president's authority. And it seems to me one reason why it's a little hard to defer to the administration is that it never really looked like the administration had tried to seek a balance between national security and individual rights, and just found that the national security side of the scale was heavier. It looked like individual rights had just never entered into the equation at all. And it's hard to defer to somebody when they haven't actually made a determination on what you think is the critical issue about how to maintain that balance.
There's another piece to the puzzle, which is Congress. And I think you could probably discern a sort of pull on the court, where the court has a sense that Congress is not functioning in the intended way as a check against the executive. Whether you want to think about it as boring a vacuum or in some other way, I think if justices thought that they were the only remaining check, if they had the feeling that Congress was in some way missing in action, which I think is a fair assessment of the way Congress has behaved since September 11, 2001, that I think could have a sort of gravitational effect on the court.
I was going to just, if I could, come at why would we apply the Chevron rationale in the national security context? And I think more generally, there are two, if you take as the justification of deference in the ad law context, this twofold. One, certainly the idea of greater political accountability, and two, some concept of expertise. In the national security context, sort of foreign affairs writ large, that is often just not going to work, I would argue. On the accountability side, yes, on the questions of sort of protection of insular minorities and individual rights and the rest of that, but because particularly in national security issues, so much of what happens is in secret, whether appropriately or not. It is in certain instances almost impossible for there to be some really, how do you have a democratic check working when there is no way of gauging what the government is actually doing? So particularly in national security context, it seems to me that the accountability argument that might favor the executive over the judiciary, the executive, let's stick with that, is less likely to be sort of persuasive or salient, certainly if things have been done in secret. And on the expertise side, too, yes, there are a lot of things that happen in foreign affairs that are about political judgments. And, maybe the quintessential example of this is the use of the deployment of forces overseas. But not everything is a political judgment. Some of these questions, and especially if we talk about expansive concepts of security and the enormously, rapidly growing role of the military is playing in society. You know, they say moot was military operations other than war, right? Which is proliferating humanitarian operations and so forth in the United States and abroad. This idea that everything the military does is somehow a political question, or more about political judgment and less about expertise and the availability of facts and analysis one can bring to bear, the sort of reality-based view of the question. I think it's going to be harder and harder to just sort of say, well, because it involves national security and foreign affairs, those really are sort of political judgment questions. I think increasingly there are arguments that they're you know, questions susceptible of expertise and factual analysis.
If I could just add to that in terms of the political accountability point, this is where I think I see a parallel between the Wyeth preemption case that Linda brought up, perhaps, and the kind of national security military issues that we're talking about here. Because if we talk about the political accountability rationale failing in the military context, whether it's because of transparency, as you're suggesting, a lack of transparency, or whether it's, as Dan suggested, because of a lack of consideration of individual interests, if we say, well, it's failing here, hence deference isn't appropriate, sort of similar to Justice Stevens in the preemption context, saying that the accountability rationale fails there in terms of him being unwilling to give deference because agencies aren't politically accountable to the states. So those federalism concerns that are coming into play in his preemption jurisprudence, I think, does have some analogy, maybe, as I was suggesting, to this discussion.
If I can, just one more footnote on this. In addition to its many other shortcomings, the Bush administration failed by failing to impress upon the country ultimately that we have been in a war status. Look around Davis, look around the town of Davis, look around the campus, look around Sacramento, look around any country, any city in our country right now, and you don't have the sense of a country at war. It's a fact. And had the Bush administration ultimately been more effective in conveying that sense, I'm not talking about the global war on terror. I'm talking about the fact that we have, you know, 6 figures of uniformed people in Iraq and Afghanistan, an equal number of mercenaries, basically, helping. Notwithstanding that, they were never able, it's passed, thank God, they were never really able to make the case that the country was at war and derive the benefit in litigative terms that comes with that. They failed in that as a matter of, you know, total packaging, if you will. Now, what if they had succeeded in that? What if they actually had persuaded the country that we were on a war footing? One wonders what sort of subliminal effect that would have had on our jurisprudence. So there's a sense in which their failure is the country's success or the law's success.
Well, I guess one thing I would add, too, is I think they undercut their credibility in some critical ways relating to these cases. So after Hamdi, the first of the major cases, they fought all the way to the Supreme Court for their power to treat this guy as an enemy combatant and not a criminal subject to the criminal process. And then they let him go, basically. They send him off to Egypt. Padilla, they get all the way. They're about to get to the Supreme Court on whether they can hold him. Finally, this is on a second round after that first decision about habeas. And they don't want the Supreme Court to hear it. So all of a sudden they decide, well, we don't need to treat him as an enemy combatant. Let's charge him as a criminal. And in fact, Judge Ludig, who was one of the most conservative stalwarts on the federal bench, attempted to prevent them from doing it and then resigned from the bench in outrage, feeling that he had been manipulated by the administration into taking seriously their claims of national security when they were really just sort of flexing their muscles and trying to establish executive power. So I think it became I think it became harder to believe that they knew stuff, right? That's always the ultimate power of the president, right? He knows things we don't know, and if we did know them, we would realize that he's right. I mean, you see that over and over again in history, and they kind of gradually gave that advantage away. I think. And so then you were left with the sense that there was just nothing much there except an agenda to broaden the scope of presidential power.
I note we're a little after time. It's clear that the panel has demonstrated that it knows stuff. I don't know, Diane, did you want to wrap up, or did you have another question?
I just can't resist talking. Is this on? Yeah. I can't resist talking about this topic, and I just wanted to make what I think is a summing sentence, that I'm glad that we evolved into a more contextualized discussion about this, because I think although the issues of deference in the formal sense are very important, I was hearing echoes of 20 or 40 years from now, someone arguing these cases the way that we heard Quirin and Johnson versus Eisentrager being argued in an incredibly decontextualized way, so that no one understood how in extremis those opinions were, and we're taking them on face value. And I think we could have the reverse problem with these. I mean, the reason there's no deference in Hamdan was because of the absence of Congress and the aggressiveness of the executive and the need of the court to check. And that may explain why the same justice who could not find jurisdiction in the first Guantanamo case, which Deborah mentioned, the Haitian cases, later finds jurisdiction in the second Guantanamo case, which is Rasul, because the context in which those came up, even if you dislike the first result, contextually, the behavior of the executive and the mix of values at stake was very, very different. And so we can't just say, well, this is a direct contradiction. So I thank you very much for kind of moving the panel to an incredibly rich discussion on this issue.
I am Ryan Stahl. I'm the outgoing editor-in-chief of the Law Review, and I'd just like to close with some thank yous. And I promise I'll be brief. I have 2 pages with their 14-point font. So, I'd like to thank first and foremost Professor Amon, who has worked with, since she pitched the proposal to us a year ago, has worked with singular focus to make this a success. And if it hasn't been singular focus, you've really fooled us all. I'd like to thank, of course, Justice Stevens and his staff for providing us with the remarks to open the symposium. Our sponsors, Kirkland & Ellis, Boutin Gibson, DeGusto Hodel Incorporated, the UC Davis School of Law, and the King Hall Alumni Fund. I would like to thank our 2 senior symposium editors, Dave Vogel, who's standing in the back, and Jamie Chan, who has left. As I'm sure a lot of you know, that it takes a million little things to pull one of these off, and if everything goes right, nobody notices. I would like to thank the administration at UC Davis, Dean Kevin Johnson, Dean Vikram Amar, Dean Adam Talley, and Dean Hollis Colwin for their support, as well as Glenda McGlashan and the rest of the law school administration. I'd like to thank our faculty advisor, Professor Shannon Weeks McCormick. For logistical support, we are indebted to quite a few people here at the school, including Jean Karinke, Ginger Welch, Gia Helwig, Joe Martin, Claudia Moraine, Faye Veers, Madeline Fisher, Pamela Wu, and Mark Hoffman for continued technical support. We'd like to thank Sam Sellers for his graphic design help. Our moderators, Dean Levy and Professors Manister and Reynoso. I'd like to recognize the symposium committee, which were editors and members of Law Review who helped out today, including Candace Jackman, Kim Lucia, John Pingle, Ashley Shively, Drew Amoroso, Charles Klinger, Eugen Park, and Matt Tolvey. I'd like to thank Jay Jungjitarat, our technical editor, who's been responsible for posting all the symposium stuff on our website. And second to last, but not second to least, Sue Jones, our publications coordinator at Law Review, who I thoroughly believe, with a staff of about 2.5, could probably run the Law Review as good as we do, but instead she defers to 28 editors and lets them make their own mistakes. And last but not least, all the speakers and all the attendees today. Thank you for attending our symposium, and we hope you enjoyed it.